In this presentation, I'm going to go over different stories that people tell about law. Those stories are referred to as narratives, and law in this sense is referred to as legality. These three narratives come from a book called The Commonplace of Law by Patricia Ewick and Susan Silby, who are both law and society scholars, and these are stories, again, that people have told them about their legal experiences. The first one involves Millie, who appeared in court on the day noted on the summonses without an attorney. She replied not guilty. The judge asked her whether her car was uninsured, and she left the scene of an accident. Millie replied her car was uninsured, so she must be guilty of that, but she was not involved in any accident because she had not been driving. The judge said aloud and wrote down not guilty because she was not driving the car. Weeks later, she appeared again with no attorney, and she saw a packet of papers in front of the judge, so she assumed the judge remembered her and her story from the previous appearance. At that hearing, the judge found her guilty and told her the license would be suspended for a year, pay a fine, and she must complete community service. However, Millie then consulted a lawyer, and he filed a motion to reopen the case. The lawyer presented the facts, and the court found her not guilty and dismissed the charges and repaid the amount of the fine. Charles was a successful businessman over many years selling reinsurance. He sold his business and signed a do not compete clause in the transaction agreement. A year later, the contract was changed to his detriment, and he argued he was owed $400,000. The company offered him a settlement of $112,000, and his lawyer advised to accept it. However, at the date of offer, Charles read the agreement, and it demanded that he re-sign the purchase transaction from the original sale. He refused. He was confident he would win and explained this is just routine. Charles further explained, now the guy knows, and I know, that my lawyer is getting paid by the hour to sit with me, and my lawyer is a good guy. He works for the largest firm in a prestigious building. He knows he is in a major league ballpark, and he is now in trouble. Jamie caught someone breaking into his car who he described as a high junkie, and he stole a chainsaw and some other items from his trunk. So Jamie grabbed the man and told him they were going to a cop. The thief turned and hit Jamie in the head with the steel pipe and then ran away. Jamie pressed charges. There was a grand jury hearing that lasted months, and the man went to jail for 6 months. However, it took months for Jamie to get his chainsaw back. At the conclusion, Jamie said, all it did was put a junkie in jail for 6 months, did nothing to rehabilitate him. Now what I would do is smack him in the head, handcuff him to a pole, and bring the police to them. I wouldn't put myself at risk again trying to bring someone to the police. The system fails because it does nothing. These three different stories about what law is can be described in three ways: before the law, with the law, and resisting the law, or being up against the law. Before the law is described as a formally ordered, rational, and hierarchical system with known rules and procedures that more or less everyone follows, or else there are consequences. It's a very common belief in law. Millie believed that law is a paperwork process, and so she believed that since the judge wrote down what she said, the judge must have understood those words the same way that Millie meant them. However, when Millie admitted that her car was not insured, she didn't realize she was responding that she was guilty. She didn't provide enough evidence or support, or didn't articulate or wasn't heard by the judge that what she meant by that was that the reason the car was uninsured is because she hadn't been driving it and had it intended to. She also didn't clearly explain to the judge that the car had been stolen. So she believed that the paperwork process would more or less find out all of these things for her, and so she took for granted these formal, ordered, rational system of known rules and procedures. And so because she didn't know those rules very well, it wasn't until her lawyer translated what Millie was saying into the story that the judge would understand in that formal system. So again, this is before the law, this idea that rules and procedures or process can be reduced to paper, and that ultimately will find the truth. The second example is with the law, and here legality is described and played as a game. It's with pre-existing rules. Those rules are part of the bureaucracy, so the better you know the bureaucracy, this is the better you'll be off. And so the assumption is that the smartest people or the wealthiest people, or what are called repeat players, deserve to win because they know how to play the game better. This is clearly what Charles believes, and he thought that he would win because he sees this as a game of skill. Charles has had lots of experience with the bureaucracy of law. When he was in the insurance business, he had organized members of his own community to stop some development of housing near his house and other people's houses. He organized that, got everybody mobilized. And so he feels confident that he can win cases, not necessarily because he's right, not because the paperwork process will figure itself out, but that he knows how to present and play the game better. This is common belief among successful types in business, right? That they believe that this is all just a big game, or that politics is marketing, right? And so if you just present yourself the right way, that's how you win. Finally, Jamie believed the law was a waste of time. This is another fairly common, it's not quite as common as before the law, but it's a fairly common experience with those who see the law as something to resist or something to be up against. And so they don't believe this. It's the opposite of before the law. They don't believe that the rules are objective and fair. They think the process is arbitrary and capricious. They don't think it's wildly unconstrained. It doesn't mean that anybody can do or not do anything, but they see it more as the inability of law to actually do anything. It's not going to accomplish anything. So in some ways it's like a game, but it's not a game you can win. And so you see that Jamie, in hindsight, thought it was a mistake to try to go through the legal process. Jamie would rather be a vigilante and take matters into his own hands. What Jamie doesn't seem to realize in that situation is that that could get him in trouble, right? He could end up going to jail, which would further reinforce his idea that law is a waste of time. You might see also Charles could lose, right? He was offered $112,000 as his lawyer. So if you saw in Millie's case, the lawyer was the one who translated the situation and got the favorable result. In the second situation, Charles is going against his lawyer's advice and trying to push for the full amount because he thinks that the lawyer ultimately will know how to win the game. So Charles might lose, and we won't know how he responds to that, but he might probably just revise what he was thinking about, saying, well, we didn't play the game well enough, or they played the game better, right? So again, it's not really about principle, it's just about how you play the game. So what do we learn from all this? Well, hopefully you learn that the law is not one thing, right? So people have different ideas about law, and that's what constructs law. That's what law is. It's the three different ideas that people have about law. So there's not one view of law. Not one is right, one is wrong. There's no way really to judge that since these three different opinions or these three different experiences of law coexist, right? The main thing is that we can see these variations. They're discernible. We're able to have wisdom about them and learn from them. And this represents three types of legal consciousness, or how people learn and understand law in cooperation with other people. And this shows that people have a certain ambivalence towards law. It's not something that they can fully grasp or fully predict or fully show how it works. They have to kind of change or shift their experiences and understandings as they move through legal institutions and other instruments or arrangements of power that we rely on law. Law can be domination through formal rules and procedures to which some people comply. Some people make a mistake and they think that all people comply to these formal rules and procedures. That's against common sense, right? We can just look outside and watch people breaking those rules all the time. And there are no consequences for most people most of the time. So it's a little bit of bad luck, if you think about it that way, when you do get in trouble for violating the rules. The other side of this, however, is that the domination is seen as legitimate. It's seen as something that the government should do as an enforcement of social norms. The problem again is whose social norms and what happens when people don't comply. So it can be domination, but it can also be a form of resistance where some people object to the unfairness and injustice and they demand rights because they don't agree with the norms or they think the norms are arbitrary. And so you see this kind of tug and war going between law as domination and law as resistance. But either way, law is still constitutive. It is the thing that creates this power struggle, this domination and resistance. And so this is because it's both an ideal. People think of it as an ideal. This is what law should be. Normative is what we say. It's something we want it to be. But it's also a space of practical action. It's what it really is. And so there's this gap here that the turtle's kind of in between on the rope between the elephant and the hippopotamus pulling the rope. The turtle is down saying, and that's the constitutive legal identity. It's kind of changing and shifting based on which side of this you're on, law, domination or resistance. So these are 3 narratives I'd like you to keep in mind so you have a better ability to analyze law as not one thing, but that it constitutes our identities as we interact and have experience with law.